Are we good?
Good morning, and welcome to Forums That Matter, a community service of the Unitarian Universalist Congregation of Cleveland. This is the second forum of the fall 2023 series, and we're operating with a new schedule, the first and third Sundays of each month. My name is Laura Christian Imbernoni, a member of the Forum Committee and coordinator for today's discussion. We're very happy to have everyone who's here in person today, and of course our virtual attendees as well. Our topic today is, does the U.S. Supreme Court have credibility? A very timely one. We'll have questions and answers with our speakers from about 9:30 until 9:55, and Marlene will provide a mic for our in-person audience. We ask our virtual audience, though, to type questions in the Q&A box. Now, if you're here in person, please be sure your phone is off or in airplane mode. This program is recorded and will be available in a few days on our website at uucleveland.org. And now, it's my pleasure to introduce our speakers this morning. They both teach in the Cleveland area law schools with individual experience and expertise. Cassandra Robertson is a professor at Case Western University School of Law. Prior to joining the faculty there, she clerked for the Texas Supreme Court and served as Assistant Solicitor General in the Office of Texas Attorney General. She received a law degree from the University of Texas, where she also obtained joint masters in Middle Eastern Studies and Public Affairs. Professor Robertson teaches civil procedure, professional responsibility, and secure transaction. She's also taught transnational litigation and remedies. She directs the law school's Center for Professional Ethics, whose mission is to explore moral choices across professional lines in a variety of disciplines. And now we have also with us Stephen Chien, who is an assistant professor of law at the Cleveland Marshall School of Law. Some of his teaching areas include criminal law, professional responsibility, comparative law, and empirical legal studies. He received a law degree from the National Shih-Chun University in Taiwan, and then a doctorate in law at Stanford University School of Law. Prior to joining Marshall School of Law, Professor Chien worked as a research social scientist at the American Bar Foundation in Chicago, where he also served as a member of the editorial committee of the lauded journal Law and Social Inquiry. So our speakers will engage in some back and forth discussion today, beginning with Stephen Chien. Stephen, we look forward right now to getting some more perspective from you.
Well, thank you so much for the introduction. Okay, let me turn on the mic. Well, my name is Stephen Chien. It's great to be here on this lovely Sunday morning. So I think my goal for the first 5 to 10 minutes is to really set the stage and sort of give you guys an idea about what lawyers and professors are talking about when it comes to the Supreme Court's legitimacy and credibility. So think about that. Dozens of states recently have changed their voting laws, since 2020. And the 9th justice of the Supreme Court might one day be asked to look at them and think about this. If the presidential election next year is close, the Supreme Court might have to step in and adjudicate. So with so much at stake, we have to ask, or we need a Supreme Court that is broadly seen as legitimate and ideally impartial. So let me begin by talking about this idea of trust. So the interesting thing about trust to the Supreme Court is that we actually have really good data. And since 50 years ago, we begin to ask American people every year, How much do you trust the Supreme Court and the judicial systems as a whole? So perhaps not surprisingly, our Supreme Court is facing a crisis of legitimacy. So this survey is done by Gallup, and they ask, like, how much would you rate the honesty and ethics of various professions, not just the legal professions, including lawyers and judges, but various other professions. So the interesting, I think the most striking finding is that they found 5 of the 22 occupations rated last year at the historical new low in public trust. So that includes judges. The majority of Americans, we continue to believe that judges, they have a little bit higher ethics compared to lawyers, but it has declined 5 points since last year to about 38%. So for lawyers, guess how much we trust lawyers? Well, only 19% of Americans have positive ratings on lawyers. So judges, they were like a little bit higher. That's good. But let me tell you this. We Americans, we have more than 70% positive rating on doctors. And even for police, it's more than 50% positive rating. So the number is shocking. But let me tell you this, another shocking finding. So as I said, only 38% of Americans think of judge as having very high or high honesty and ethics standards. So the issue is judges have seen a gradual erosion of their ethics ratings over the past decade. And it reflects a decline, a general decline among both majority parties. So no matter you are Republican or Democrat, your trust on our judicial systems decreased. And perhaps it is also not surprising that our confidence specifically to the Supreme Court is also at a new low. How much? Anyone want to guess? Well, only 25% of Americans have confidence in the Supreme Court, and it was down from 38% in 2021. So public confidence in the Supreme Court have been low over the past 16 years than it was before. So I pulled out the data and looked into the historical data last night. So let me tell you this, between 1973 and 2006, an average of 47% of Americans were confident in the Supreme Court. 47%. It was down to 25%. So in other words, Americans' opinions of the Supreme Court are the worst they have in the 50 years of polling. So trust overall is declining in many other US institutions in recent years. But the loss of faith and legitimacy in the Supreme Court is especially notable, given the high level of trust it has enjoyed historically. So the second part, I want to talk a little bit about, when we talk about trust or legitimacy, what are we talking about? So interestingly, political scientists gave us a really good starting point to talk about legitimacy and support to the Supreme Court. So I often told my students, even though we know the Supreme Court is extremely powerful, but in fact, it is one of the most vulnerable institutions that we have in this country. Why? Well, think about this. The Supreme Court, it lacks the electoral connection to provide legitimacy. And the court, many times, is asked to stand against the wind of public opinion. Also, the Supreme Court, from time to time, is asked to protect the rights of those who's not popular in our society, like criminal defendants. And finally, The Supreme Court, they cannot enforce their own decisions. And that's why we need to talk about support and legitimacy of the Supreme Court. So when political scientists talks about support, they often talks about two types of support. One is called specific support. Another is called diffuse support. So in short, specific support is your support to the institution based on specific point in time. So the specific support could change based on the decision of the Supreme Court. But this idea of diffuse support is not about what you think about specific decisions of the Supreme Court. It is about your trust to the institution. Historically, the diffuse support to the Supreme Court was pretty stable, not until recently. It just plummeted. So there's a diminished support of the Supreme Court. So there are various reasons, like ethical scandals, other issues related to the use of shadow docket. So I want to begin the discussion by asking Professor Robertson, does the US Supreme Court has any ethical codes? Do they follow the traditional things, the ethical codes that we have for judges in this country?
Great, thank you so much. It's a great segue. So in short, no, not really. So, with the title of this forum being, does the Supreme Court have credibility? We heard a lot of jokes kind of coming into this that, oh, no, it's easy. The answer is no. Okay, we're done. Let's go have some coffee. And it's kind of not entirely a joke, right? Because with this 25% support and trust in the court, yeah, I think we're starting from a position of no, the public really is at a very low point in trust of the Supreme Court, and that's a problem. Because if the people don't have faith in the Supreme Court, and if maybe they reasonably can't have faith in the Supreme Court, that's a real problem for the rule of law in general. And that's been for more than 200 years, really a foundational bedrock principle of the United States in general. So yeah, I'm gonna look at this question of what can we do about it? When we're at a low point, what can we do about it? And Stephen asked the question, does the court have a code of ethics that could give us some faith in the court's operations? And I'd say no, because the 9 justices of the Supreme Court are the only federal judges that are not bound by the code of conduct for United States judges. So there has been a lot of criticism of that fact, a lot of suggestions that they should also be bound. Some of the things that the code does, the code normally places limits on federal judges' partisan activities, including, for example, restricting federal judges speaking at partisan fundraising events. They're not allowed to do that. Limiting sources of outside funding to ensure that outside financial interests aren't affecting judicial decisions. Requiring disclosure and recusal when a judge does have a conflicting interest, whether that's a financial interest or a personal interest. So with the justices on the Supreme Court not being bound by the code of conduct, it's understandable you see a lot of controversy over just those things, right? Over when do judges recuse themselves? What kind of financial interest do they have? What kind of financial interest do they disclose? To what extent are they participating in partisan political activity? So, I and many others would like to see the court adopt a code of ethics. Where that gets difficult is Congress has from time to time tried to propose various kind of externally imposed codes. There is a separation of powers problem there, that normally the code of ethics would come from the judicial branch so that you don't have one branch of government putting restrictions on what another branch of government can do. So, of course, the court could preempt all of those discussions by adopting its own code. I feel very strongly that they should do that. So not only, I think, should they adopt a code of ethics, I think the court should communicate to the public a lot more about what its internal standards are, and importantly, when its internal standards are breached, to let the public know that certain behavior might be unacceptable, communicating when a justice fails to meet the standards the court would impose. So for example, right now, justices decide on their own when they might have a disqualifying bias that would stop them from hearing a case. One change I'd like to see is to have the court as a whole review those individual decisions. Right now, they largely do not. So if one judge thinks, well, I'm pretty good friends with this litigant, and maybe we co-authored an editorial together, and now he's here before the court asking for something, no, but I think that I am not such good friends with him that I should recuse. Right now, a justice makes that decision, there's no review. Having the court actually review that decision and say, yes, we think that a reasonable person would find this disqualifying versus no, we think in this situation a reasonable person would not find it disqualifying. It's too tangential. So, more scrutiny on that. Why we don't see that yet. I think there's a lot of collegiality still between the 9 justices, and they kind of don't want to criticize each other. It makes it very difficult when you're sort of sitting in judgment of your colleagues and friends. But I think it's necessary. I think it would encourage more self-scrutiny if a justice knew that their decision was going to be reviewed by their colleagues. It would encourage the justices to think not just about how they feel themselves about the situation, whether they personally believe that they can be fair, but also to think about how it looks from an outside perspective. Another proposal that I've seen that I strongly agree with is that there should be an ethics officer inside the court who can give advice about compliance with ethical norms, especially about financial disclosures. We've probably all seen the news recently about things that were left out of various justices' financial disclosures and then later revealed. Yes, okay, quite familiar, it sounds like. Well, part of the problem there, at least the justices said, oh, I talked to my colleagues and former colleagues, and they said I didn't need to disclose this. Perhaps that's true, but it would be really great to have an ethics officer who could, again, review that kind of situation, give official advice. And in the event that the ethics officer said, no, this wasn't something that needed to be disclosed, that would be very powerful for the ethics officer to be able to say to the public, yes, the justice asked me about this situation, and I did not think it was something that required disclosure. And then people can have more trust that the justices are complying with the norms that are expected of them. So why do I think these steps are necessary? Certainly to increase public trust. And I think also we need to talk about reducing the risk of public corruption. Judges and justices, absolutely, people generally tend to get a little bit offended when their integrity is questioned, when the question of corruption is even raised. People get defensive, it's human nature. And certainly the vast majority are absolutely honest and doing their best to comply with ethical norms. But in recent years, we have in fact seen corruption from public officials. Most recently, allegedly with Senator Bob Menendez. Here in Northeast Ohio, we've seen state trial court judges arrested for corruption. And we certainly know that these Supreme Court justices are being courted, being wined and dined and flattered by people with interest before the court. So I think some level of transparency and oversight is needed to guard against a slide into corruption and the risk of corruption. Again, that may not be a problem now, that probably is not a problem now, but without some level of oversight and transparency, I think there's a risk of that. And I think the more the public sees corruption in other spheres in life, the more they worry about that. And if there's no transparency, they have no way of knowing, and trust is lost. Another proposal has been to increase the size of the court. And it's kind of interesting that while there might be a constitutional problem with Congress directly adopting a code of ethics to apply to the court, Congress pretty much unquestionably has the ability to shape the size of the court. So you may have learned quite some time ago in history classes that way back in 1935 to 1936, there were such proposals on the books by FDR. And famously, we've probably all learned in school about the switch in time that saved 9, where the Supreme Court was striking down a number of New Deal enactments in 5-4 rulings that appeared very partisan. So in the history doesn't repeat, but it rhymes division, It was very similar to the situation we're facing today. Justice Owen Roberts very famously switched his views. He upheld the constitutionality of minimum wage legislation, and that kind of ended the period of the court striking down the New Deal enactments. After that, they were largely upheld. And momentum was lost to enlarge the court. And after that, the New Deal largely survived court review. So as a result, the court has stayed at 9 members since 1869. People are starting to question whether it should be, if we allowed new justices to be appointed, could there be any principle of restraint? Could we ever go back to thinking that the court is above politics, or would expanding the court just make it more political? There have been some proposals that are limited enough that I think they would have some real benefit. So for example, HR 5140 is a bill proposed in Congress that would appoint a new justice in every odd numbered year going forward. So very slowly expanding the court at a timeline that we'd be kind of binding our hands. We wouldn't know whether those appointments would be Democratic appointments or Republican appointments going forward. And then the idea is after 18 years of service, justices appointed after the enactment of this law would take senior status and wouldn't hear ordinary cases coming before the court. However, they would still get would continue to pay them because justices are constitutionally allowed to hold office in terms of, as long as they are engaging in good behavior. So they would continue to get paid. They could return to the Supreme Court when there was a vacancy. They could be available to hear cases if other justices were recused in a case. They could potentially hear some of the procedural issues coming up in the shadow docket, which Stephen will talk about. So I think this could be a good idea. It could avoid some of the individual pressures on the judges. It could allow for stricter recusal standards. Some of the arguments against recusal right now, the justices say, well, yes, I'm friends with this person, or yes, I had dealings with this person, but there's only 9 of us. I need to be on the bench to hear the case. If there were, in a sense, a deeper bench and senior status justices who could be appointed to hear a case, then in theory, at least, justices would be more willing to recuse in cases where their impartiality might reasonably be questioned. So we have a few minutes left before questions, and I think Stephen will introduce the idea of the shadow docket, and then we will open it up for questions.
Yeah. It's actually a very interesting idea about reforming the Supreme Court. And I know that there are actually many proposals, like adopting the ethical codes, adding more justice to the court. But we also know that maybe there's a way to limit the tenure of the justice, or even impeach some of the justice who's involved in these scandals. Or we can limit the jurisdictions of the Supreme Court. And finally, some even said that maybe it is time for some of us to disobey the decisions of the Supreme Court. So those two, like having an ethical code and having the, ethics of officials, right? So those are really good ideas. But I think the first reaction is that, well, last year, the Congress actually passed a law requiring more transparency about financial disclosures. And I looked into the law last night, and I think it was really weak because, the justice, they still have a lot of discretion to decide whether it is reasonable. So I think the bottom line is, a lot of the time we think the Supreme Court is self-regulated. And that gets to the challenge of the Congress, governing the Supreme Court. So a few months ago, there's actually a new bill. It was being discussed at the Senate's Judicial Committee. And I think the bill's title is called the Supreme Court Ethics, Recusal, and Transparency Act. And I like this idea because the act will require the Supreme Court to adopt a binding code of conduct and then to establish a process. But I guess my concern is that Democrats no longer have the majority in both houses and Congress. So I'm just not sure whether this kind of external regulation will be possible. So I guess at the end, it really goes back to the autonomy of the Supreme Court to decide what is their own codes of conduct. And then, back to this idea of lack of transparency. one of the greatest concern I have is really the increasing use of the shadow docket. So many of you might heard of this term, shadow docket. So when we talk about Supreme Court's job, we tend to focus on the bright lights. But the work of the Supreme Court is actually divided into two main categories, the merits docket and the shadow docket. So the majority of the rulings each springs that we see in which the justice, they have lengthy opinions. They were lengthy opinions, they have full procedures, they hear arguments for both sides. Those are the merits docket. There were about 60 to 70 decisions every year. But by volume, most of the Supreme Court's work come from these unsigned, unexplained, and really opaque order, known as the shadow docket, or known as the orders docket. So although it is as old as the Supreme Court, the use of these unsigned and unexplained docket, it really increased in recent years. So most of the time when we talk about the shadow docket, we said that its effect is quite limited. It addressed some emergency issues. It is related to some procedural issues. So we were told that we can ignore it, and so that we did. But since 2017, that's changed. The Supreme Court's new conservative majority is using these incredibly opaque order and proceedings to intervene far more often in some of the most controversial issues in our country. So because they are unsigned and unexplained, shadow docket orders are supposed to be exceedingly limited in what they can accomplish. And yet, we see that dozens of times in this Supreme Court, we now see shadow docket orders that flies in the face of those understandings. And it really hurts the Supreme Court's legitimacy if, as professors, we're telling our students, these are the Supreme Court's rulings, but we don't know what's the rationale. There's no way that we can defend it. And that's why it is hard for us to have a conversation with our law students about what's the relevant social policy and whether we can actually justify the social policy. So I think the final issue that we really have to focus on is this uptake of the use of shadow docket. And I will stop here. I want to have more conversations with you. Yeah.
So thank you so much, Stephen and Cassandra, for sharing your time and expertise with us. If you would like to receive weekly reminders of our forums, please add your contact information on the clipboard as it comes around. And if you're joining us virtually, please add your name and email address to the chat box. And now it's time for our attendees to ask questions of our speakers. It's always one of the very best parts of the forum. We'll look at the Q&A box online for questions from our virtual audience, and I'll now turn the question and answer session over to Marlene.
And please, when you use the microphone, make sure it's close to your mouth and it's horizontal.
Hi, thank you. I think the trust in the Supreme Court began to erode during the Clarence Thomas confirmation hearings. I have seen no action on the court that indicated any interest in having the American public trust them. Quite the opposite. It's like asking Ohio legislators to pass a fair redistricting program. It's not going to happen. So does any outside body have any influence? For example, don't they have to have law licenses? And can't the bar associations in the state go after them, or the American Bar Association?
So interestingly, they don't have to have bar licenses, not required. Yeah, so bar licenses are really, they are done at the state level by the states for practicing attorneys. So somebody who is a federal judge does not need to be licensed by any state. So yeah, I think that is a hard one. I do think, I think you're right. I think the court has not shown a real interest yet in kind of in improving public trust. I think that's a problem for the court because the court can't enforce its own rulings. And at some point, if the public loses trust enough, they will quit following Supreme Court rulings. You know, we saw during the Trump years, we actually saw Trump suggest that if the Supreme Court ruled in ways he didn't approve of, he just simply was going to ignore those rulings. And that's a real risk. The court will lose power if they don't restore some sense of public trust. You know, whether they do it soon enough, I don't know. I remember very well the Thomas hearings. I was a college student at the time, and I remember watching Anita Hill and watching the hearings and feeling that, you know, my view of the hearings was that Anita Hill was very persuasive and that I did not believe that Justice Thomas was telling the truth. And I did believe that Anita Hill was telling the truth. And it was horrifying to see what I believed somebody committing perjury was then getting appointed to the Supreme Court. But I will say there was a difference back then in that there wasn't the same partisan split that we see today. And there was more of a gender difference in who believed what back in those days. And both Democrats and Republicans, to some degree, supported Justice Thomas and believed him over Anita Hill. So that has changed today. There is people voting much more on partisan lines. And I think this is problematic at a couple of levels. It is problematic for appointment to the court. That I think when justices are put forward, even when there are very serious issues in their background that maybe should give senators of all political affiliation some question, that there tends to be pretty quick votes on partisan lines without a lot of investigation into people's backgrounds. That's a problem for appointment. Impeachment, we see also becoming very divided on partisan lines, at least, you know, with, you know, certainly the presidential impeachments that have been tried, the discussion now among Republicans of impeaching President Biden for something, not clear what, but this sense of impeachment being a partisan issue, because impeachment is supposed to be kind of the ultimate oversight that Congress has, right? Congress has power, especially the Senate, has power over appointment, and it has power over impeachment if somebody really violates the public trust. And when those things become just flat out divided on partisan lines with nobody actually doing a deeper analysis, Congress loses those tools of oversight. So it is difficult. Congress is supposed to have some power there. They have not been exercising it, and that creates problems.
Yeah, I agree with everything you said. And I think one of the most shocking thing is that when you heard former president refer to the three justices as my judges, that's a really shocking moment. And it really goes back to this, you know, idea of the lack of transparency and this, for instance, the uptake of the use of the shadow docket. You know, I remember Alina Kagan once said that, well, it just, this kind of use of the shadow docket makes, you know, the everyday become more unreasoned, inconsistent, and impossible to defend. And I agree with that. But you also heard that some justice said that, well, the complaint about the Supreme Court only comes from those people who disagreed with the outcomes of their decisions. I don't think so. I think, you know, no matter who you are, which party you belong to, we should care about legitimacy. We should care about procedural justice, transparency, and really to have Supreme Court to bring the sunlight into this shadow docket and other potential ethical concerns that people, Americans, will have. So I think it is really the time for them to, even though we believe that the Supreme Court is a self-regulated institution, and they do have the power historically, but it is time for them to step up and really adopt the ethical codes and really to have the procedure being transparent to all of us.
Thank you. The whole system, as we know, looks to be veering from ugly sausage making, which it always was, to partisan warfare. And particularly one side thinks all is fair in war. So Professor Cassandra, I'm a little surprised, if I heard you right, you implied we're not in full-blown corruption yet. I love you, smile. But considering the new revelations about Alito and Thomas, why do you think so?
Oh wow, that's a great question. I mean, and maybe my trust is misplaced. My impression is that the justices are not questioning their actions enough, but I don't believe that they've crossed the line into actual corruption. But you know what? The fact that I can't defend that with evidence is a problem, because it means that we lack the right kind of oversight. I think with the right kind of oversight and transparency, it should be a lot easier to make that defense with actual facts and evidence and not just gut feeling. So I'm sorry, I don't have a better answer for you.
I'm a physician, and if I accept any gift from a drug company, even a cup of coffee, that's considered corruption. Why is this allowed for Supreme Court or any other justice?
Well, we know most of the federal employees are barred from accepting any gift worth over $20. But that kind of code is not applied to the Supreme Court. So I don't know, do you have a good, can we justify this?
No, absolutely, we cannot justify this. We've seen justices go out of their way, I think, to try to accept gifts that are less likely perhaps to require reporting, which is also a problem in and of itself, right? Accepting a ride on a private jet, accepting a trip on a yacht, is that meaningfully different from accepting more kind of direct financial benefit? Probably not. Why they're allowed to do it? Well, because possibly no external body is able to impose an ethics code, and the Supreme Court has not adopted one on its own with any real teeth. Is it a problem? Yes. Should it change? Absolutely yes.
Good morning. Thank you very much. Really enjoyed your presentation, in part because I see it in front of me, two lawyers I actually believe. It's kind of a magical moment. At any rate, you mentioned civil disobedience in a sense to the law. I watch sometimes sovereign citizens on television saying that they don't simply follow admiralty court law and that they're on their own. What would civil disobedience look like with this very low percentage of support for the Supreme Court in situations like Roe v. Wade and others that are quite controversial and a significant majority of Americans don't agree with? What would that look like? What would people do that would say that I'm not going to follow this regulation?
So I think, one, at the Supreme Court level, most of the cases that the court hears are very high level constitutional cases, because they have the discretion to take the cases that they want to take. Which means when you look at who is most likely to decide to disobey a court ruling, it is probably whoever is in the White House. And that to me is a little bit scary, because I think there is a difference between the two parties in their willingness to obey the law. So I would be worried if the Supreme Court loses so much legitimacy that the person in the White House does not obey a Supreme Court ruling. I think that's a problem. In the past, we can see so there were also situations we saw in the 60s where state governors didn't want to accept Brown v. Board, right? So they were the ones who were resisting the court's rulings. And the federal government had to bring in federal troops to protect the law, to integrate the schools, to make sure that people were protected. So I'm nervous about the possibility of the court losing so much legitimacy that people decide not to obey court rulings.
Yeah, and well, I agree with everything you said. And one thing I want to add is that I'm also concerned that if the Supreme Court keeps losing its legitimacy, it will sort of hide even more into the shadow. So because the use of the shadow docket is chaotic, it has covered so many issues that we don't think it should be done with a shadow docket. So from abortion to asylum, from elections to executions, from, we have seen this in, abortion cases, COVID restriction cases. So now we can see most of the time we think the shadow docket should be used to maintain the status quo. But now there's a growing number of cases where we see the Supreme Court is using the shadow docket to change the status quo. So one thing that I'm really concerned is that if there's a really lack of this fundamental legitimacy of this institution, it will keep using these shadow powers to gain more powers. And at the end, it will get just even harder for the democratic society to control and have a solid oversight to this really powerful institution in our democracy.
Thank you so much. Thank you for your presentation. I have a question about, you mentioned an 18-year term for the judges. I've read about such things. My view, and I know a lot of people will disagree with me, but honestly, I don't see any ephemeral wisdom out of these guys that any of us in this room couldn't have come to the same decisions. We just couldn't have worded our opinions as elegantly. And to me, Supreme Court justices, choosing them now has become no more than a verbal beauty contest. I'd like to know your opinion on why the heck these people deserve an 18-year term. Why isn't it a 5-year term? They're not indispensable. They can be replaced with a million other judges. And at this point, I'm happy to let both of you know, my opinion of lawyers is a lot higher than my opinion of judges. And I was surprised the opinion of the Supreme Court was at 25%. I honestly thought it was going to be about 13%. Last I read, or maybe I'm thinking of Congress, it was down below venereal disease in popularity. I don't think anything of any of them, and that includes the liberals, because the darn people just don't know when to resign.
So
get them all out in 3 years. I'm down with it.
So I think I would find it risky to have shorter terms than 18 years.
I'm sorry, did you say risky?
Risky. And the risk I see is that if somebody was going to be on the court for such a short period of time, then they're looking at what are they going to do next. And I think that their rulings for the period of time they'd be on the court might be aimed at what are they going to do next. We've seen this on state courts with judges serving shorter terms on state courts and then going to work for very lucrative clients.
Wait, you can't make a rule based on something the person may do after they're out of office. You can't do that. Pass a law saying that they can't do that. That's a crazy way to make judges, to appoint judges or decide their term.
It's definitely difficult. I will say, the criticism that judges are not necessarily meaningfully different or meaningfully better from ordinary people and ordinary people's ability to reason, that has been made since absolutely the founding. And that to some degree is true. I think the main differences that we see with judges, especially at the federal court level, especially at the Supreme Court level, is that they tend to come from a very elite stratum of society. And that's a problem. And interestingly, that was identified as a problem even at the founding of the country. That, wait a minute, what kind of power do we want to put in the judiciary when the people who are in the judiciary come from this very elite strata and don't necessarily understand the pressures facing ordinary people? So I think, I think that is true. Judges tend not to be meaningfully better in their ability to reason, and they do tend to be meaningfully more limited in their background and their kind of understanding of societal issues generally. Yeah, do you want to try on the timing?
The term limits, right? Yeah, no, I think this is a really interesting area for comparative scholars like me to look into that, because that idea is actually pretty common. Like in Taiwan, the Supreme Court justice, the Constitutional Court justice, they have a term limit of 8 years. And it is possible to have, I think, a procedure and to have the mechanisms at play to sort of protect the judicial integrity, the independence of the justice, while also set some kind of term limits. But I think there's just a lot of areas to explore in the future, and I think it is possible.
I have two questions. One is mine and one is from online. My question is, we have so many petitions that are circulated to get things on the ballot. In an ideal world, could we have a national petition that would either require the justices to recuse themselves or to ask for a resignation?
I like that idea. Yes, but it probably wouldn't be binding. I think if there were going to be sort of collective action among the people, it would probably be for a constitutional amendment. And we are seeing some movement in that direction. We historically have not had a large number of constitutional amendments, but it could happen, and there could be some limits on the court in that way, whether it's term limits or other limits. Could there be like a petition to ask for recusal in a specific case? I think we've seen some of that. Back when Justice Scalia was, duck hunting with a friend who would appear before the court, that was very controversial. There was a lot of outcry. I think there were some petitions. It didn't carry a lot of weight. I don't know if that would change.
My question from online is, has John Roberts addressed the issue of public trust of the court in any meaningful way?
Yeah, well, I can just give you one example. So in July, when the Senate Judiciary Committee held the public hearing, they actually asked the Chief Justice to come, but Chief Justice refused to come. And I think this idea is that among the 9 justices, there's just lack of the necessity to have this conversation, because they don't think there's any need to pass an ethical code for the Supreme Court, because everything is done correctly according to the Chief Justice. So I don't know, it's difficult.
Any more questions?
At the beginning, you talked about the trust of the public in the Supreme Court going back 50 years, but do you have a sense of that in a more historical sense? Have there been, and also has there been as much partisanship around the Supreme Court going back far into history?
Yeah, well, the historical data is interesting. So what Gallup is trying to measure is actually about specific support. So that support level actually fluctuates depending on the major cases. So after Doe, it just drops, right? But there's another type of support that political scientists will try to measure, which is the support to the institution. And historically, it was really stable until recently. So now people are trying to figure out what happened, because we know for the specific support, it really changed depending on who you are, your background, and which party you support. But that shouldn't be your support to the institution as a whole, as part of our democracy. So at that point, we found out that both Democrats and Republicans, they both lose the support to the Supreme Court. And that was really shocking because it tells us it is not about the decisions, right or wrong, right? Depending on like what legal jurisprudence you support or what moral backgrounds you have. That changed. But your support to the institution shouldn't change. And now we see both Republicans and Democrats, they just lose support to this institution, which is really shocking. And scholars were still trying to figure out what happened. And there's a lot of reasons behind that, right? There's no transparency, lack of ethical codes, and many other reasons. And we still don't have clear answers to that question, unfortunately.
You were talking about public trust and support for the legal system. And I think if you ask that as an abstract question, you get one kind of an answer. If you ask it from somebody who's been before the legal system, they tend to have a huge emotional attachment to the lawyer who defends them and the legal system, and a trust that they're going to be dealt with fairly. And they would probably give quite a different answer. So I don't know if it's worth looking at that as another way of looking at overall trust in the legal system or the court.
Yeah, that's a great point. And we see that even with Congress. Nobody has faith in Congress as a whole if you ask the public, but you ask people about their particular representative, they often have a much higher opinion of the one that they are personally familiar with. That personal connection makes a huge difference. The Supreme Court has always been kind of remote and removed from the public. I do think if it took more steps to communicate with the public, it has resisted cameras in the courtroom. It only recently allowed for arguments to be live streamed orally. But I think, the closer connection that the court could build with the public, that might increase trust as well.
Thanks so much for your presentation. It's great. I just want to note that I think we've got to be careful about taking much comfort in popularity votes of the Supreme Court, even if it goes down to 13% or 5%. I think eventually the right, the MAGA side, is going to figure out that they should start voting in support or polling in support of the Supreme Court, especially since they're getting the bulk of what they want from it. And I think if they start polling the way they're, up into the 40 or 45 range, then I think the media will say, oh, look at that. The Supreme Court is now popular again. And it's, and then, sort of take it off the table. So I would just, it's a comment, not so much a question, but I would beware of taking much comfort in that. Because they already decided in some states they said, don't vote, to the MAGA crowd, don't vote. This is all fixed. And then they said, oh, wait, that's not a good idea. So they may catch on that they should be voting, for their own purposes, supporting.
Yeah, I actually, it's a very interesting point. I actually put out the data earlier today. And so let me tell you this. So the Republicans' positive rating for judges actually descended from 55% in 1999 to 38% last year. It remains about the same at about 40s today. Okay, but Democrats, the positive rating for judges was also descend from 54%. It's the same in 1999, but after which it just plummeted to about 36% in 2022, the data that we got from last year. So I think both Republicans and Democrats, they lose trust to our judicial systems, and which is really surprising.
I'm interested in pop culture. Freedom Playhouse right now has a play called Burke, a one-person show. I don't know if either of you seen it. It's interesting from the point of view, first of all, that he's African American, and second of all, the major education decisions were things that he acted on, Brown, Plessy, and others. I wonder if things like that reveal more of the inner workings of both the court and the minds of the individual justices, and maybe make them more approachable to us.
Yeah, I think so, absolutely.
Yeah, I like that idea. And part of, me, being an educator is that you need to be able to tell students what's the rationale, who are these judges, what's their judicial, jurisprudence or their philosophical ideas. You need to be able to tell this and just having a conversation with your students. So I think that's one of the ways that, they have to be transparent, tell us what they think and let us know who they are. I think that's just the first step to build the trust of the society.
Thank you.
Thanks again to our speakers and to all. Yeah. So much. To all the forum committee members working together to make this hybrid forum possible. Thank you, everyone who attended virtually, and to everyone who's here in person. Please join us in 2 weeks from today, Sunday, October 15th, when the forum topic is the Fifth Estate, 21st Century Watchdogs. Our speakers are Lila Mills, editor of Signal Cleveland Digital Newspaper, and Phil Trexler, editor-in-chief, The Marshall Project, Cleveland. They'll talk about the rise of the Fifth Estate for digital media and how digital journalists assure accountability, what they report, and how they make a difference. And now you're welcome to attend the 10:15 Sunday service upstairs in our sanctuary or on UUCC YouTube page. Reverend Dr. Randy Partain will lead the service today with the intriguing topic, choirs and cacophonies. Mike Carney and the Chancel Choir will lead a new original song, plus music from Leonard Bernstein and Bernice Johnson Reagan. And you could probably hear them a little bit if you're here today through the open door practicing for us. To see what else is happening in our congregation, check out our website at uucleveland.org. Thanks again for joining us. Have a wonderful week.
Thank you both.
So thank you so much. Your interaction is great.